really kind of three time frames in my mind when you should make a will. Who can tell me those three time frames when you might want to consider making a will?
When you get married, you have a child, and you get divorced.
I heard when you get married, and I heard when you have a child. The last one I heard is when you get divorced. I'll give you 2 out of 3 on that.
Grandchildren. You have grandchildren.
Grandchildren. Yeah, the basic rule of thumb is, if you run it right, when you first get married, it's a good time to consider making a will. You're probably in your, well, as we were talking, it used to be you're in your 20s, now it's when you're in the 30s or 35 or 40. That's a good time to consider making a will to make sure that, you know, your future assets, because you never know when you're going to start. Assets kind of sneak up on you. You start out getting married, you don't think you have anything, and pretty soon you find that you have quite a bit. When you have children, is a really good time to do it, especially for naming a testament guardian for your children. And what do you do? What do you think you have to do when you go about thinking about naming a testament guardian? You just walk in to the attorney and say, "Yeah, I want so-and-so to be my testament guardian." Is that not right? Well, if you do that, I'm going to tell you that what you need to do is to go talk to the person to make sure they're willing to do it, because the last thing you want to do is nominate somebody and have them turn you down on doing that situation. So if you're going to want to do that, is there anything you might want to do? Want to ask a question? Nope? Okay. Those are the things that we do to make a will. We're going to expand the authority of the executor. That's what the person's called who winds up the estate. We're going to waive a bond requirement for them. And right now, if you don't waive a bond requirement, the statutes in Ohio would require you to post a bond to serve in that capacity. It's kind of a stupid expense because you're naming somebody that you, or somebody's doing the capacity that you have trust and confidence in. And those expenses for that are about the same premium cost as it would be for house insurance. So you're talking $300–400. In most cases, you're talking around $75 to $80 to have wills made. So you can see right now that's a good reason to do it. You can consider naming a testament guardian for children. If you have a child with, as this gentleman back here said, with special needs, then we can talk about several different things. And there's things that have to roll in that you have to consider when you're talking about a child with special needs. And that is, should we be setting up a trust for the child? That's what you asked about. And in most cases, yes, it's going to be the answer to that. That trust, though, is not usually a freestanding trust that people are thinking about these days. It's actually a document that's contained in the will that becomes effective when you die, and you'll make certain provisions for the care, maintenance, and support of the child. But if that child has a situation, I was talking to the gentleman here earlier, that is on some sort of public assistance, or is going to want to be on public assistance in the future in the form of SSI or Medicaid or some of those kind of concepts, then you're going to have to be very careful and let the attorney know, and you're going to have to draft the trust provisions so that it's not just for their care, maintenance, and support, because if it is, they're going to require you to contribute that to spend down. And I'm kind of jumping into it, but do any of you know what the current threshold is for Medicaid purposes? What amount of assets you can have? I'm going to give you a range. You tell me which one you think is right. $10,000, $50,000, $1,500, $3,000. $1,500. Okay, that's exactly right. It's $1,500 that you're allowed to have in assets if you have to go on to Medicaid, or you have to spend down your assets to those. And there's several ways you can try to avoid that situation. One of them is to put the money in a trust situation, but if you put it in a trust situation, it has to be in what we call a bubblegum trust, or the luxuries type trust, where you're only spending it for TVs, cars, those kinds of things for somebody, and they can't be used for their care, maintenance, and support, because if it is, they're going to pull it back in. There's another little ugly feature of Medicaid right now, too, that you may want to be aware of, and that is the look-back period. And let's play the same game again. The look-back period, let's say, how many of you think it's 3 years? One. How many of you think it's a year and a half? Nobody. How many of you think it's 10 years? Okay. I'm getting more, 4 of you now. How many of you think it's 7 years, the old 7-year concept? I got 2 more of you. 7? How many of you think it's 5? It is 5. It is 5. It was, since I've been practicing, it was about a year and a half at one time, and then it was 3 for a very long period of time, and then for the last about 2.5 years now, it's been 5 years. So anything you do, what that means is anything you do to make your estate not subject to Medicaid coming back and taking the assets is going to be looked back for a 5-year period of time. So you have to plan ahead on these things when you're thinking about doing that kind of estate planning.